I will be quite shortly. History of trademark is a long time. Our first act was in 1894. It has been not changed up to 1949. Then the new Trademark Act under the EU Trade Directive came in force. 3 different trademarks registers. You know, we have the EPO register, we have the national, and we have also the register of the international trademarks, international registered trademarks. The personal exchange and cooperation with the OIP, first time we had a lot of employees in the OIP, but moment I think 3 or 4. We had in the head of the office a vice director, and then a director who is now president of our court, Mrs. Schmidt, Beate Schmidt. She was working with Campino together. By the way, our trademark department of the patent office is about 250 people, and the patent department have more or less 1,000 people, and therefore 850 patent examiners. This the divided jurisdiction I told you in the patent lecture. The Federal Patent Court is only responsible for appeals against the decisions of the Trademark Office or Patent Office. Civil Court takes the infringement cases. Structure of the administration in our court, we are divided in teams of 6 to 10 persons dealing with the whole trademark application up to the opposition procedure. And there is an internal appeal. If you are not happy with the first instance decision made by a qualified officer, you can call for an appeal to a lawyer. We call it the Erinnerung. But there's no need to do so. You can go also right down to the patent court after the first instance. The experts were qualified in our office. Mostly they are officers coming from other offices in Germany. So they will have a 3 years qualification. After that they are allowed to make decisions. It is a so-called semi-judicial procedure, refusals prepared like a court decision, and we have the right to be heard after, but just before the decision will have taken. Abstract color trademarks, I do not tell you. I go ahead to the protectability by origin of color trademarks. It was sought for, under the other forms of trademarks, a red for saving banks. It is not originally distinctive for, but this red was applied for elastic fastening straps, neither for elastic straps consisting of PE film for securing goods on pallets, as claimed in the auxiliary request. The general public is aware of the primary color described as traffic red, inter alia on traffic signs. A specific, well-delineated market segment does not exist, since the elastic fastening straps are also used in the home and garden, and not just for packaging and transporting goods. The signal color is used for decorative elastic ribbons or drawing attention to the fastening. Since the elastic fastening straps are offered in a variety of colors and shapes, the broad target audience would only perceive the color as a decorative or functional design feature. The addressed employees in packaging and transportation would only perceive the color of elastic straps consisting of PE film for securing goods on pallets as a warning. Then they tried another case. This is the saving banks, Red, tried to get protection by acquired distinctiveness. I know that the same by a secondary meaning. I don't know how to tell that. Secondary meaning, that means not only descriptive, but also a declaration to special enterprise. And the contour-free color mark Sparkassenrot, registered as having acquired distinctiveness in July 2007, was cancelled by the 25th board following the ruling by the European Court of Justice on the preliminary ruling of the 33rd board. This collective mark of a Deutsche Sparkassen- und Giroverband lacks original distinctiveness for the field of finance, that is, retailing banking services for private customers, since the relevant end consumer in the banking sector is not used as ascribing a color for a specific bank. Red is one of the most familiar primary colors, which a pronounced signaling and symbolic effect, which is frequently used in different areas, including that of banking, in designs for branch offices, advertising, and various associated products due to its marked recognizability and attractiveness. There are many businesses in the banking sector, for example, also the Santander Bank, and given the limited number of distinctive colors, not everyone is able to distinguish itself by color. Even though some financial service providers use specific colors, these are primarily employed together with elements that are indicative of origins, such as the name of the financial institution, associated abbreviations, symbols, logos, or other decorative designs. Federal Patent Court ruling liable for cancellation of services of class 36. The appeal was admitted because it addressed relevant fundamental legal issues and a deviation from the ruling by the Federal Court of Justice, inter alia, with regard to distinctiveness in cancellation proceedings for marks that have been registered as distinctive. Yeah, just back. We had another case in the practice. It was the color of British petrol. You may know it is green and yellow, and they asked for a abstract color combination. And first time the court has refused it because the description is not clear and sufficient enough. And this was cancelled by the Federal Court of Justice by saying it should be, the description is enough. And during that time, there was, when the case came back to us, the European Court of Justice decided that just this description, who was used for another color combination, it was yellow-blue, and said this description is not sufficient. So what to do now? Normally we are bound by the higher court and the decision in our case, and we decided not to be bound and saying it is now, the description is not enough, and leaving the appeal, and it has made by British Petrol, and our Supreme Court said the German Federal Court was right to do so. He saw the National Court, Supreme Court, was overruled more or less by another decision, not in the same case, but another decision by ruling that this sort of description is not sufficient. We were a bit anxious to do so, but it was more or less the first time a court didn't follow the appeal the remedy decision. Yeah. But, okay. So we have here a three-dimensional mark. It's a cube of nuts of grains. Yeah. And the court said a cube is not so different to other bar shapes, mainly considered as decorative or practical, no inherent fanciful character. For me was another question, how to use this three-dimensional trademark, because normally all the bars are different. They don't have all the same shape. Yeah. So the trademark cubes of nuts and grains lacks the necessary distinctiveness, since the visual difference within the branch between a cube and the routine bar shape is small and fluid. Furthermore, the addressed public would primarily consider the cube shape of nuts and fruits and grain snacks useful or perhaps decorative, but not indicative as originating from a particular undertaking. The sharp edges, look here, spaces between the combined nuts and non-uniform surface structure do not reveal any independent characteristic, either by themselves or in combination, and the consumer is only aware of type and shape of the goods offered in this manner. When confronted with a cube-shaped snack product consisting of nuts, dried fruit and rice, the public is furthermore clearly deceived in its justified anticipation of a savory snack. We had the word mark oui, French word for yes, and in former times another court, the federal court refused the application, but the Federal Supreme Court cancelled this decision. It was in the end of last century, maybe 97 or something like that. It was another applicant, and now our board said it is anyway, yes, it's known for the domestic consumers of fashion, only an advertising appeal in awakening the customer's attention with respect to the French culture, especially for fashion. The former decision of the Federal Court of Justice should be overruled by its new practice in the case Hay. But the remedy was taken, and quite freshly, the Federal Court of Justice told us no protection, no hurdle if customer consider or other way around, no protection. Only in that case, the customer consider the word exclusively as an advertising appeal. We had it the same, I think, with the European Court of Justice. I think it was Audi, Vorsprung durch Technik or something like that. And they said it may be descriptive, but it may be also a trademark. For me, it's the one side or the other. It's not both cannot be for me. It's only in that case you have acquired distinctiveness. Here we are, we have this figurative trademark. That means first well, and contains a general positive endorsement. The goods are first place in a ranking, and in addition good. That means special quality. You have to think about what does it mean. It's first good, and so the applicant says it would be distinctive because it's not clear the content, but our court said it is clear enough. Okay? Time partner, your best partner. These are slogans. The court said it's it is distinctive. No specific factual statement because time is not a suitable descriptive attribute of partner, time partner. Maybe in the marriage, I don't know. Only non-specific associations to be services hiring out workers to third party, because the hired workers are not partners of the employer. So it should be fanciful. And now this is up to you. It's up to you. What do you think about up to you? Don't look to my comments. Yes, the court said, not obviously descriptive, although the elements are comprehensive, the sum is more than the single elements. The slogan is sufficiently distant to the correct formulation. It's an application for you. See it, feel it, live it. Just an emotional advertisement to get at the emotions according to which the services are supposed to offer positive experience. And there's a very gray zone to handle. Is it distinctive or is it only descriptive? Is the slogan more than the parts of the word, the single words, and not? In this case, they said it's not. It is not so easy to give reasons to emotional advertisements. Is it only an advertisement or is it more? Be connected. Orally identical to be, that contains service-related information to advertising anyway, if the slogan in its German translation can be understood as a personal or a technical connection. Maybe both. This is Schloss Shop Heidelberg, figurative trademark. The ruins of the Heidelberg Castle are the embodiment of German Romanism and draw about 1 million visitors every year. In the Schloss Shop, you will expect the common assortment of souvenirs, which is found within the proximity of such attractions. The stylized silhouette of the Heidelberg Castle reinforces this assumption. Actually, I didn't recognize the shape of the Heidelberg Castle in that. It is only an assumption. But it has been refused because they say it's only a reinforcement, so and the other words are descriptive. Another one, the Prague Philharmonists. Since cities can have several philharmonic orchestras, the wording is exclusively descriptive, but the graphic element, stylized silhouette of the Prague Castle, is distinctive and sufficient for protection and sufficient for protection in a whole. You may say it is not really clear, you won't see it on the first view, and is it very sufficient? But they said, and maybe if you read Prague, you will find the cathedral there, or maybe the Tower of Prague, and maybe a reinforcement as well. Yeah? So there's I think there's a collision between this case and this one. It wasn't the same board. Oh, this is a nice trademark. The figurative trademark represents a QR which the customer attributes purely the access function to additional information, retrievable through technical means. And if you look very closely, you will find here a K and an O with points on it. And this was the idea of the applicant by saying, it's K, it's a word, it's nothing of, nothing descriptive. So it should be protectable. But the court says the letters K in the middle of the image are distorted and inconspicuous to such an extent that they are only perceptible if examined closely. Even if perceived, the letter would be interpreted as a code, related coincidence, and not as an indicate of origin. I agree completely. And now we have some, you know what it is? Shit on it. And we have some of these trademarks which are a violation of morals, especially with alcohols, with spirits, and so on. And we had the word ficken, and the court allowed it as a not immoral because he said ficken is a normal word of German language now, and it's popular, and so it's not immoral. But the Civil Court of Justice cancelled that by saying, and if only in a few words, this is not allowed in Germany. Ficken is so here it fails to exceed the bounds of an ironic fun saying with a simple graphic design in black, because it's not much. Striking bold print that only reinforces the attention-grabbing comment. And maybe you can't read it. A significant majority of society also finds this vulgar statement of disgust a serious violation of good taste. In the context of social interaction in business life, such crass expressions are considered transgressions of appropriate social behavior. In numerous literary or film contexts, the word shit or similar expressions are frequently used artistically to intentionally provoke, which assumes and partially necessitates the generation of offense. However, liberalization has not progressed to such an extent that the use of an expression drawn from the lowest level of language as an officially registered mark is not considered vulgar. Next one I have to warn you, but it is in our report in headfuck statement fashion, violation of morals. Headfuck consists of English terms which are current in Germany, and it's translated into German as Kopffick, which designates in a highly vulgar manner the sexual practice of fellatio. Even though the expression may describe a state of mental confusion in a figurative sense, it is understood by a broad segment of the population in terms of its original sexual connotation. Statement fashion is only perceived as a secondary descriptive reference to fashion that conveys a message. Consequently, groups of individuals who are casually confronted with the mark are primarily aware of the highly vulgar sexual expression. Now to the opposition procedure. You see here two bees in a circle. And there was no likelihood of confusion. What do you think? Because there are additional words. Black can, you cannot confuse with that one. And it is, the letters are clear enough and not too small. They said it's enough. On the other hand, or in addition, the B is a more weak trademark, and the figuration of the B is different, so it may be another ground for not to be confused. Here we have Colorderm and Dermacolor. If there is a rule that in the combination of figure and words, the word will be first to be mentioned, and Colorderm and Dermacolor, it looks descriptive. Yes, that is the reason. Merely switching around the elements of the mark, similar to the transposition of sounds in an anagram, fails to overcome the likelihood of confusion. However, the opposing mark achieves its distinctiveness solely from the specific combination of the individual components which are not eligible for protection and are a part of a basic vocabulary of the cosmetic branch. Consequently, their scope of protection exclusively covers the sequence of the elements of the mark by which the comparative marks differ and which overcomes the likelihood of confusion. The use of similar exclusively descriptive word elements fails to establish any danger of confusion on the basis of legal grounds, because they are weak, the words, color and derma. So the scope of protection is very, very low. Sometimes it is reduced up to the identical trademarks. Here we have two stars, a cartridge star and another cartridge word. The distinctiveness of the opposing mark is slightly less than the right. This one is the right one is opposing mark, slightly less than average, since cartridge, as an English word for the German words Kartusche, Patrone, Kassette, is descriptive with respect to printers and copiers. Word is also restricted to a descriptive meaning, as it describes a comprehensive line of products within a store or in the internet. Furthermore, no significant above-average similarity exists between the marks because the two depictions of stars are significantly different in terms of their specific design. On the one hand, black with 7 evenly distributed points and a light-colored arrow which surrounds it. On the other hand, a yellow arrow with 5 points with red, blue, black edges and a smiling face. I think the left trademark is protectable only because of the eyes and the mouth within the star. Others is descriptive or only not distinctive. Here we have an opposition procedure between McSpice and McDonald's. What do you think about? There's only a similarity of Mac and Mac. And normally Mac, as you may know from Scotland, is not much. Huh? A moderate likelihood of confusion exists because the opponent is the proprietor of a large number of series marks with the element Mac, which, as the court is aware, have been used for years in the field of fast foods. Actually, I don't agree. I think it is more a concept of a trademark. And although McDonald's is quite well known, yes. But I wouldn't think that is Max Spice. It's only because of the reputation of McDonald's.
So what was the answer?
Yeah, it is confusable. Yeah. Have been used in, oh yeah, the answer is confusable. And what's your answer? No.
I always think I confuse everything, but not these two.
Yes. And I think that's the last case of mine, opposition based on good reputation. That's quite new ground of opposition to unfair advantage or infringement of the distinctive character of repute or known marks, person to paragraph or to section 9, paragraph 1.3. Taking advantage of the distinctive character or repute of a known mark is assumed when a third party attempts to use a mark similar to the known mark, even when the goods and or services of both parties are dissimilar. To ride on the coattails of the known mark and profit from its appeal, reputation and prestige without offering financial recompense or exert any independent effort, or to participate in any other manner in its notoriety. A level of similarity that causes the relevant classes of persons to conceptually associate the two marks without, however, confusing them with each other is sufficient. The grounds of opposition were affirmed in the case Springen der Pudel of the Federal Court of Justice. And now, here's our case. It is in Germany well-known hotel Adlon, very close to the Brandenburg Gate. And it has a long history, political importance, and everyone would know it in Germany. And this was a Bauservice GmbH, that means building society. Apparently, the older mark functioned as a designation of one of the most luxurious hotels in Berlin and represented provision of rooms and board for guests. The comparative mark exhibits greater than average similarity. Beyond the identical opposing mark found in the more recent mark, the additional words elements are visually subordinate and merely descriptive. Since major hotel chains also offer consultation services pertaining to renovating and building vacations, residences, and apartment hotels, the consumer of the property developer services could be left with the impression that the residential buildings possess a comparable level of quality or similar comfort as that of the familiar luxury hotel. Thus, without any personal legitimate interest, the proprietor of the more recent mark would profit from the appeal of the opposing mark, which enjoys a high level of familiarity and renown in a relevant proximate area of service. For my opinion, it is not a case of the registering and the rules of confusing trademarks. It's a case of competition law. Then you can look. This would be the border in between, because we don't look for evidence. We had to decide for experience, of rules of experience, and how to decide would the people find it's different, it's similar, and so they will have a better reputation because of the name Adlon. I don't know. That's up to you how to decide. Thank you very much.